Right now, there is a single sheet of paper sitting in a file at your old employer's plan administrator. And when it comes to your 401k, that sheet of paper legally outranks your will. It outranks your trust. In documented Supreme Court cases, it has outranked a divorce decree, sending retirement money to an ex-spouse the account holder divorced years earlier. If you haven't seen your beneficiary form since you filled it out, you do not actually know who inherits your retirement account. There is one free form that fixes all of it. And the reason most people have never been told it exists is simple. Nobody whose job depends on the current system has any incentive to tell you. My name is, if this kind of information is useful to you, hit subscribe because every week I break down the financial and legal facts that protect your money and your family. And I make sure you actually understand them. Here's the fact that will matter most by the end of this video. The United States Supreme Court has ruled, unanimously, that a retirement plan must pay the person named on the beneficiary form, even when that person gave up the money in a divorce. Your will controls your probate estate, the property that passes through the court process after you die. Here's what almost nobody explains. Your 401k is not in your probate estate. Neither is your IRA, your pension survivor benefit, or your life insurance. These are contract assets. They pass by the contract, and the contract is the beneficiary designation form. For workplace retirement plans, the controlling law is federal. The Employee Retirement Income Security Act of 1974, ERISA. Two provisions matter. First, 29 U.S.C. Section 1104A(1)(d), the Plan Documents Rule, requires the plan administrator to pay benefits according to the plan documents. The beneficiary form is a plan document. Second, 29 U.S.C. Section 1144 ERISA preemption says federal law overrides state laws that relate to the plan. That includes state inheritance laws. That includes, in key situations, your state's probate code. Now the two Supreme Court cases, because this is where it stops being theory. In Egelhoff v. Egelhoff, 532 U.S. 141, decided in 2001, a Washington man divorced and died 2 months later without updating his beneficiary forms. Washington had a state law that automatically revokes an ex-spouse's beneficiary status on divorce. The Supreme Court ruled that ERISA preempts that state law. The ex-wife, not his children, was entitled to the plan benefits because her name was on the form. Then, in 2009, Kennedy v. Plan Administrator for DuPont Savings and Investment Plan, 555 U.S. 285. A man divorced. His ex-wife expressly waived her rights to his retirement savings in the divorce decree. He never updated the beneficiary form. He died. The Supreme Court ruled 9-0. The plan administrator must pay the ex-wife named on the form. The signed waiver in the divorce decree did not change what the plan had to do. Here's the counterintuitive fact to sit with. A court-approved divorce decree, signed by a judge, was not enough to redirect that money. A one-page form would have been. One more layer, and it runs the opposite direction. Under the Retirement Equity Act of 1984, written into ERISA at 29 U.S.C. Section 1055, your current spouse has automatic rights to your workplace retirement money. For a 401k, your spouse is generally your beneficiary by law, and naming anyone else, including your children, requires your spouse's written, witnessed consent. A form naming your kids that your spouse never signed off on can fail. So the errors run both ways. The form can pay someone you no longer intend, and the form can be overridden if spousal consent was never properly obtained. What happens by default if you do nothing? Whatever the form on file says, filled out on your first day of work, maybe 30 years ago, is what happens. Not what your will says, not what your family assumes, what the form says. Harold is an illustration, not a real client, but this pattern is drawn straight from the case law you just heard, and it repeats constantly. Harold is 74, a retired electrician from Michigan. He did everything the responsible way. After his first wife passed, he remarried at 66. He hired an estate attorney. He signed a new will leaving everything to his second wife, Anne, with the remainder to his 2 adult children. The will was drafted, witnessed, and notarized. It cost him $1,800. He put a copy in the safe and told his kids where to find it. What Harold never touched was a form he filled out in 1989, his first week at the electrical contractor where he spent his career. On that 401k beneficiary form, he named his first wife, and as contingent beneficiary, his brother. His first wife has passed. His brother and he haven't spoken in a decade. When Harold dies, here is what the law does. His will governs his house and his bank accounts through probate. But his 401k, the largest single asset he owns, goes to the plan administrator's file. The administrator is required by 29 U.S.C. Section 1104A1D to follow the plan documents. Primary beneficiary, deceased. Contingent beneficiary, the estranged brother. Under Kennedy, the administrator doesn't weigh fairness, doesn't read the will, doesn't call Anne. The form controls. Anne's remaining option is litigation, suing the brother after the payout, arguing around federal preemption. Estate litigation of that kind routinely runs tens of thousands of dollars in fees and can take years with no guaranteed outcome. The will Harold paid $1,800 for never had jurisdiction over the account at all. The fix that would have prevented every bit of it. One beneficiary form, requested from the plan administrator, filled out with Anne's name and his children as contingents, with Anne's spousal rights already aligned. Cost? $0. Time? About 15 minutes. Harold did nothing wrong by the logic he was given. He was told a will is how you control your legacy. Nobody told him his biggest asset doesn't listen to wills. This is the most expensive false comfort in estate planning. A will, even a flawless attorney-drafted one, governs probate assets only. Your 401k, IRA, pension survivor election, annuity, and life insurance all pass outside probate by designation form. If your designations contradict your will, the designations win on those assets. The practical cost. The account passes to the wrong person, and your intended heir's only remedy is a lawsuit, commonly tens of thousands in legal fees, often against a family member, with federal preemption working against them. Think about when you completed your beneficiary forms. First week on a job, day you opened the IRA, the year a child was born. Now count the life events since: deaths, a divorce, a remarriage, grandchildren, an estranged relative. The form does not update itself. And per Egelhoff, for an ERISA plan, you cannot rely on estate law to clean it up automatically after a divorce. An outdated form is not a small clerical issue. It is a live instruction the administrator is legally bound to follow. The cost is the entire account. For many retirees, 6 figures, delivered to someone you'd never choose today. Here's the reversal that surprises people most, in both directions. Direction 1. Your divorce decree said your ex waived the retirement account, so you consider it handled. Kennedy versus DuPont says otherwise. The plan pays the name on the form, waiver or not. If your ex is still on the form, your ex is still in line. Direction 2. You named your children directly, thinking that's the protective move. But if you're currently married and your spouse never signed a proper written consent under 29 U.S.C. Section 1055, that designation can fail. Your spouse's federal rights come first. The move that feels decisive, a decree, a quick form naming the kids, creates a contested account unless the spousal consent piece is done correctly. The repair, done in advance, is a form and a signature. The repair after death is a courtroom. So here's what I want you to do. The exemptions, the breaks, the refunds, most seniors already qualify for, but never claim. I've put them all in one place, state by state, form by form, so you don't waste hours digging through government sites. Everything's laid out fast and simple, so any senior can find exactly what applies to them. No matter what state you're in, there's money you're leaving on the table. It's called the Senior Exemption Playbook. It's in the first pinned comment right below this video. Just tap it once and you'll have everything you need. Now stay right here, because the last section covers the one form that puts you back in control of every retirement dollar you have. And it's the reason I made this whole video. Step 1. Make a list this week of every retirement account and policy you own. Every 401k, including old employers, every IRA, every annuity, every life insurance policy, every pension. Old statements and tax forms, 1099-R, will jog your memory. If an old employer was acquired, call the current company's HR or benefits line and say, "I'm a former employee locating the administrator of the retirement plan I participated in." Step 2. Request your current beneficiary designation in writing from each administrator. Use the phone number on the statement. Say, "I'd like written confirmation of the beneficiary designation currently on file for my account." Do not accept a verbal answer. The whole point is what the file says. Step 3. Compare every designation to your actual current wishes and to your will. Any mismatch between the form and the will means the form wins on that account. Check names, percentages, and contingent beneficiaries. A missing contingent is how money lands with an estranged relative or falls into the estate and back into probate. Step 4. File change of beneficiary forms wherever needed, with spousal consent handled properly. Full legal names, no nicknames. If you're married and naming anyone besides your spouse on a workplace plan, the spousal consent section must be signed and witnessed exactly as the plan requires. An unwitnessed consent is the seed of a future contest. Step 5. Get written confirmation back and store it with your will. The confirmation letter or updated designation copy is your proof. Keep all of them in one folder with your estate documents and tell the person who will handle your affairs where that folder is. Step 6. Do what would have saved Harold. Treat every major life event as a beneficiary event. Divorce, remarriage, a death in the family, a birth. Each one triggers the same 15-minute review. If you have divorced and remarried at any point, make this week's review non-negotiable. Egelhoff and Kennedy are both divorce cases. Step 7. Calendar a full designation review every 3 years. Administrators merge, records migrate, and memories drift. A recurring 3-year check of every form against your current wishes is the cheapest estate protection that exists. It costs nothing. Litigation costs everything. The tool is the beneficiary designation form, one per account, requested directly from each plan administrator or custodian. It is free. There is no filing fee, no attorney requirement, no government office. Its legal power comes from the same law that created the problem. Under ERISA's plan documents rule, the administrator must follow it. The form that can defeat your will is the same form that, kept current, makes your will's job easy. Here is the mechanism, step by step. You contact the plan administrator, the company on your account statement, and request your current beneficiary designation in writing. You review it. If it's wrong or blank, you request a change of beneficiary form. You complete it with full legal names, social security numbers, dates of birth, and the percentage share for each beneficiary. You name primary beneficiaries and contingent beneficiaries. The contingents matter, as Harold's story showed. If you're married and naming anyone other than your spouse on a 401k, your spouse signs the consent section, witnessed as the plan requires, typically notarized or witnessed by a plan representative under 29 U.S.C. Section 1055. You submit it and request written confirmation of the designation now on file. Processing is typically days to a few weeks. Now, what this form does not cover. One form covers one account. Your 401k form does nothing for your IRA, and each IRA has its own form with its custodian. IRAs are generally not governed by ERISA's spousal consent rule, but state law, especially in community property states, can give a spouse rights anyway. The designation form still controls the payout, and it still must be current. Bank accounts and CDs are separate again. Those use payable on death, POD designations at the bank. And your pension's survivor benefit election is usually locked at retirement under its own rules, but confirm what election is on file. Each account is its own contract. Each contract has its own form. Right now, a sheet of paper at your plan administrator legally outranks your will on your biggest asset, and that stays true tonight, unless you request that form this week and correct it. The system is not broken. It is working exactly as it was designed to work. The plan pays the name on file every time, no exceptions. The beneficiary designation form operates on that same track, and when it's current, it's the strongest estate document you own. Call each administrator this week. Ask for your beneficiary designation in writing. It costs nothing. It takes 15 minutes per account. And if you found this useful, subscribe.